What if the house you grew up in, the one your parents spent 40 years paying off, didn't actually belong to you the moment they passed away? What if a single overlooked sentence in a government document could legally strip your family of every cent of their hard-earned inheritance, leaving you with nothing but a bill for the remains? Could you survive the realization that the very system designed to protect the elderly is actually a silent partner waiting to claim their entire estate as its own? Today, we are exploring the chilling reality of the Medicaid Estate Recovery Program, a legal mechanism that turns the American dream of generational wealth into a fleeting illusion for thousands of families every year. There is a profound, surprising lesson at the very end of this story that could save your family's future, so stay with us until the final moment. Welcome to Legal Wins USA. We bring you powerful stories and legal cases just like this one, insightful narratives designed to empower and inform you. Don't forget to subscribe for more. The nightmare usually begins not with a lawyer, but with a hospital bed. For the Miller family, it started on a Tuesday in late October. Arthur Miller was a man who believed in the tangible. He believed in the soil of his 3-acre property in Virginia and the strength of the brick walls he had maintained since 1978. He was a retired engineer, a man of precision who had mapped out his retirement with the same rigor he used to design bridges. He had a modest pension, a small savings account, and a home worth $600,000. To Arthur, that home was his legacy. It was the physical manifestation of 40 years of labor, intended to be the foundation for his grandchildren's education. But as Arthur's health began to decline into the fog of dementia, Sarah found herself facing a financial labyrinth she was never trained to navigate. The cost of long-term memory care was $10,000 a month. With his savings depleted in less than 2 years, Sarah did what millions of Americans do. She applied for Medicaid to cover her father's care. She saw it as a lifeline, a social safety net her father had paid into through decades of taxes. What the social worker didn't emphasize, and what the fine print buried in a mountain of bureaucratic jargon, was that Medicaid is not a gift, it is a loan, and the state always collects its debts. Arthur Miller was the quintessential self-made man, a reflection of the mid-century industrial boom that promised stability in exchange for loyalty and sweat. He spent 35 years at the same engineering firm, rising from a junior draftsman to a senior project manager who oversaw the construction of state highways that still connect the Shenandoah Valley today. His wealth wasn't flashy, it was foundational. It was the kind of Tier 1 financial security built on a bedrock of compounded interest and a steadfast refusal to live beyond his means. He and his wife, Martha, lived in a colonial-style home that smelled of beeswax and old books, a property that had appreciated nearly 800% since they signed the deed in the late 70s. Arthur understood the mechanics of physics and the rigidity of steel, but he was blind to the fluid, predatory nature of modern probate law. He believed that having a simple will typed on a manual typewriter in 1985 and kept in a fireproof safe was his ultimate shield. He assumed that because he had paid his property taxes on time for 4 decades, the sovereignty of his home was absolute. By the time Martha passed away in 2018, Arthur's cognitive decline was a slow, creeping shadow. Sarah, his only daughter and a high school history teacher, moved back home to care for him. She watched as her father, once a master of complex blueprints, began to forget the layout of his own kitchen. The transition from home care to a specialized memory care facility was not a choice made out of convenience, but out of a desperate need for safety. The facility was pristine, professional, and devastatingly expensive. At $120,000 a year, Arthur's modest portfolio of stocks and his pension were liquidated within 24 months. This is the moment where the trap is set for the middle class. To qualify for Medicaid, an individual must essentially be impoverished, often restricted to no more than $2,000 in countable assets. However, in most states, the primary residence is considered an exempt asset during the applicant's lifetime. Sarah felt a wave of of relief when the application was approved. She believed the house was safe because the state told her they wouldn't touch it while her father was alive. She didn't realize she was merely witnessing the quiet ticking of a financial time bomb. As Arthur lived out his final years in the quiet hallways of the facility, the state was meticulously tracking every cent paid for his room, board, and medical supplies. Every dose of medication and every hour of nursing care was being tallied on a ledger that Sarah never saw. She maintained the house, paying the insurance, the utilities, and the landscaping out of her own modest salary, convinced she was preserving her father's greatest gift to her. She imagined the day she would sell the property to fund her own children's university tuition, or perhaps keep it as a sanctuary for her retirement. She was operating under the common yet fatal misconception that Medicaid is a traditional entitlement program like Social Security. In reality, under the Omnibus Budget Reconciliation Act of 1993, states are federally mandated to seek recovery of the costs of long-term care from the estates of deceased Medicaid recipients. Arthur's home wasn't an exempt asset, it was a collateralized loan. The state wasn't just providing care, it was effectively buying the house 1 month at a time without ever signing a purchase agreement with the heirs.
The true nature of the trap only reveals itself in the silence that follows a funeral. Arthur Miller passed away on a cold morning in January, leaving behind a legacy Sarah believed was carved in stone. Within weeks of the burial, while she was still sorting through his collection of vintage drafting tools and hand-drawn maps, a letter arrived in a plain white envelope. It wasn't a condolence card. It was a formal notice of claim from the state's Medicaid Estate Recovery Unit. The document was dense, written in the cold, clinical language of administrative law, but the bottom line was hauntingly clear. The state was asserting a lien against Arthur's property for the total cost of his long-term care, $482,000. Sarah sat at the mahogany dining table her father had polished every Sunday for 30 years, staring at a figure that represented nearly 80% of the home's total market value. This was the secret clause of the American healthcare system, a mandate that transforms the state into the primary beneficiary of a middle-class estate, jumping to the front of the line ahead of children, grandchildren, and named heirs. The legal mechanism at play here is a sophisticated form of subrogation that most families ignore until it is too late. Because Arthur had not placed the home into an irrevocable trust at least 5 years prior to his illness, the property remained part of his probate estate. In the eyes of the law, the state had become a preferred creditor. Sarah's status as the daughter and the designated executor of the will meant almost nothing in the face of federal recovery mandates. She quickly learned that the simple will Arthur had signed decades ago was a paper shield against a digital sword. The state's claim wasn't just a request for payment, it was a cloud on the title that prevented the house from being sold, refinanced, or transferred without the government getting its cut first. Sarah reached out to a specialized estate attorney, hoping for a loophole, a mistake in the paperwork, or a hardship waiver. She was met with a grim reality. The law was functioning exactly as intended. The state argues that by recovering these funds, they can sustain the program for future generations, but for families like the Millers, it feels like a targeted extraction of the only wealth they ever possessed. The attorney explained that while some assets are protected, the home is the ultimate prize for recovery units because of its illiquid nature and high value. Sarah discovered that if her father had married a younger woman, or if she herself were a person with a documented disability, the state might have deferred the claim, but as a healthy, self-sufficient adult daughter, she fell into the demographic that the recovery program is designed to squeeze. The suspense intensified as Sarah realized that her own financial contributions to the house, the new roof she paid for in 2021, and the property taxes she covered to keep the lights on were now essentially gifts to the state. She was effectively maintaining a property that the government was already in the process of seizing. The fiduciary duty she felt toward her father's legacy was now in direct conflict with a bureaucratic machine that viewed her father not as a citizen who had contributed 40 years of taxes, but as a debtor whose account was finally being settled. The house was no longer a home, it was a balance sheet, and the state was about to collect. The psychological weight of a legal battle against the state is a slow-acting poison that trickles into every corner of a family's life. For Sarah, the betrayal wasn't just coming from the government, it was manifesting within her own family tree. Arthur's house, once the center of holiday dinners and childhood laughter, became a source of toxic resentment among his siblings and Sarah's own cousins. They had all operated under the assumption that the Miller estate was a massive, untapped reservoir of wealth that would eventually trickle down to them. When the news of the $482,000 lien broke, the initial shock turned into a frantic search for someone to blame. Sarah's uncle, Arthur's younger brother, who had always harbored a quiet envy of Arthur's success, began to accuse Sarah of financial negligence. He claimed that by moving Arthur into an expensive facility instead of caring for him at home, she had effectively handed the house over to the state. He threatened to contest her role as executor, arguing that she had breached her fiduciary duty to the other potential heirs by failing to shield the assets from the Medicaid recovery unit. The family meetings, once filled with stories of Arthur's engineering feats, descended into shouting matches over look-back periods and asset transfers. Sarah found herself caught between a relentless state bureaucracy and a family that felt entitled to a legacy that was rapidly evaporating. The emotional betrayal cut deeper than the financial loss. She had spent 5 years sacrificing her weekends, her savings, and her emotional health to ensure her father died with dignity, only to be branded as the person who lost the family fortune. The pressure mounted as the state's recovery unit sent a formal demand for a sale of the property to satisfy the debt. Sarah was living in the house at the time, surrounded by her father's blueprints and his collection of slide rules, feeling like a squatter in her own history. She realized that the state didn't care about the emotional value of the mahogany table or the height marks carved into the doorframe. To them, it was simply a liquidatable asset. The conflict reached its peak during a pre-trial mediation session where the state's attorney sat across from Sarah with a stack of invoices detailing every catheter, every meal, and every hour of laundry service her father had received. The clinical coldness of the accounting was a stark contrast to the warmth of the memories Sarah was trying to protect. The state argued that every dollar they spent on Arthur was a dollar that belonged to the taxpayers, and Sarah was standing in the way of a mandated reimbursement. Her own lawyer whispered that fighting this further would only deplete what little equity was left in the house through mounting legal fees. Sarah was faced with a devastating choice: continue to fight a losing battle against an entity with infinite resources and a fractured family, or sign the documents that would effectively hand the keys to the state and walk away with nothing but her father's drafting tools. The internal fracture was complete. The house was standing, but the family that gave it meaning had already crumbled under the weight of a legal loophole they never saw coming. The gavel fell, not in a crowded courtroom, but in the sterile silence of a judge's chambers where the fate of 40 years of labor was decided in under 10 minutes. The court's verdict was a cold affirmation of the state's superior position. Because the Miller family had failed to engage in proactive Medicaid planning, specifically by not utilizing an irrevocable trust or a life estate deed at least 5 years before Arthur's nursing home admission, the property was legally categorized as an available resource for recovery. The judge noted that while the emotional toll on Sarah was evident, the law was unambiguous. The state's lien was valid, and the house had to be sold. Sarah stood in the driveway one last time, watching a real estate agent hammer a sign into the front lawn, the same soil her father had spent his weekends tilling. The final outcome was a liquidation sale that fetched $620,000. After the state's nearly $500,000 claim was satisfied, along with the realtor's commission and the closing costs, Sarah was left with a check for less than $40,000. The resolution of the Miller estate served as a brutal autopsy of a middle-class dream. The wealth that Arthur Miller had meticulously engineered to support his lineage was diverted into the coffers of a state healthcare system, leaving his daughter with barely enough to cover the legal fees she had incurred trying to save it. The family conflict that had erupted during the process left permanent scars. Sarah's uncle stopped speaking to her, convinced that a better lawyer or a different strategy could have saved his perceived share of the inheritance. The betrayal felt total.
Sarah realized that the system had essentially forced her father to spend down his life's work to $2,000 just to get help, and then waited for his death to take the one thing he was allowed to keep while breathing. It was a perfectly legal, perfectly clinical extraction of generational wealth that happens every day in probate courts across the country, often without a single headline or a word of protest. As Sarah packed the last of her father's belongings into her small car, she found a hand-drawn map he'd made for her when she was 6 years old, showing the best places to find ladybugs in the backyard. That piece of paper was now the most valuable thing she owned from the estate. The house was no longer a sanctuary, it was a closed file in a government cabinet. The legal loophole hadn't just taken the money, it had erased the physical evidence of her father's existence. The state had won, the creditors were satisfied, and the neighborhood moved on, oblivious to the fact that a family's foundation had just been dismantled by a few paragraphs of fine print. Sarah drove away from the brick house for the last time, beginning her own life with a profound understanding of how fragile the concept of ownership truly is when the state becomes your primary care provider.
The karma of the Miller case is not found in a sudden windfall or a cinematic reversal of fortune, but in the cold clarity that Sarah gained through her loss. She realized that the state is not a safety net. It is a creditor that offers a high-interest loan secured by the roof over your head. The evergreen financial lesson hidden in the wreckage of Arthur's estate is the absolute necessity of the 5-year look-back rule. Wealth preservation in the modern era is not about how much you earn, but how early you protect it. If Arthur had transferred his home into an irrevocable trust or a life estate deed at the first sign of a tremor in his hands, or even 5 years before his cognitive decline required professional intervention, the state would have had no legal standing to touch the property. The house would have bypassed the probate process entirely, moving directly to Sarah as a protected inheritance, shielded from the grasping reach of the Medicaid estate recovery program. This is the Tier 1 financial reality that the wealthy understand, and the middle class often ignores until the ambulance is in the driveway. True fiduciary duty starts in the living room, decades before the courtroom. It requires a difficult, unsentimental conversation about the mortality of both the parent and their portfolio. Sarah eventually used her remaining $40,000 not to buy a new car or pay off her own debts, but to establish a comprehensive estate plan for herself. She recognized that the greatest gift she could give her own children was not just a house, but a fortress of legal protection that no government agency could breach. She became an advocate for elder law transparency, teaching other families how to navigate the distinction between exempt assets and recoverable ones. She learned that in the eyes of the law, silence is consent for the state to step in and manage your legacy on its own terms. The story of the Miller estate is a cautionary tale for anyone who believes that a simple will is sufficient to protect a lifetime of work. It is a reminder that the legal system operates on precision, not on sentiment. The house that Arthur built is now owned by a young couple who have no idea about the engineering marvels he once designed, or the daughter who fought to keep his memory alive within those walls. But Sarah's story lives on as a blueprint for others. The profound, surprising lesson is that the only way to truly own your estate is to give it away legally before the state has the chance to take it. Generational wealth is a relay race, and the handoff must happen long before the finish line is in sight. By understanding the mechanics of irrevocable trusts and the timing of asset transfers, you can ensure that your home remains a sanctuary for your family rather than a line item on a government balance sheet.